Scotus Ruckus. Produced by inlexveritas.com.
This is Lexi Toteberg, a reporter for Scotus Ruckus. Thank you for tuning in. Scotus Ruckus is a program dedicated to giving our viewers an in-depth look into the cases pending in the Supreme Court of the United States, through the lenses of the oral arguments. With me is our legal analyst, Dave Weinstein. Thank you for coming in.
Thank you, Lexi.
For this series, the case we are looking at is Spokeo, Incorporated versus Robbins. For some of the background information, please refer to Part 1. Dave? To recap, can you summarize the procedural posture of this case, that is, how the case got to the Supreme Court?
Sure. Thomas Robbins, a resident of California, brought a suit under the certain sections of the Federal Credit Reporting Act, in the United States District Court, the Central District of California, against Spokeo, Incorporated. Spokeo, a defendant at the District Court, is a personal information data aggregator, operating a website at spokeo.com. The case was dismissed upon reconsideration for lack of standing. The interlocutory appeal was made by Spokeo from the unfavorable ruling below to the Ninth Circuit.
If I may interrupt. Viewers might not be familiar with the term interlocutory appeal.
Okay. The term denotes a technical procedure with detailed rules, but our purposes here, let's say, an interlocutory appeal is an appeal of a ruling by a trial court that is made before the conclusion of the trial. So, for our case here, there was no full trial at the District Court, but the standing issue got in the way, and the case was interlocutorly appealed to the Ninth Circuit. Plaintiff, Thomas Robbins, lost in the District Court, but in effect won in the Ninth Circuit. Defendant, petitioner, made a petition for certiorari. Now, the two sides are ready to rumble at the Supreme Court. Plaintiff respondent, Thomas Robbins, versus defendant petitioner, Spokeo, Incorporated.
Thank you, Dave. Now, let's continue with the virtual coverage of the oral argument.
Your Honor, I think
most of the common law rights, like property rights, are given to you by statute. They're not given to you by the common law. Most people are coming in to sue on the basis of a statute.
And the question is that there are several ways that they can establish standing. One is to have the tangible harm to meet the general tangible harm test that this Court applies generally in the standing context. And that can be economic injury, it can be other kinds of injury, and the Court has applied that in a wide variety of contexts. The Court has also it is also clear that in the property rights context, when Congress just doesn't create, or the common law doesn't just create a right to sue, but confers a property right, the right to exclude generally, as the Court has put it, that any intrusion on that property right, on that right to exclude, is tangible harm. And the Court has made clear in the college—
If I have a dozen or more cases that didn't involve property rights, where we didn't require economic harm, those would mean nothing to you.
Your Honor,
those legal rights, we just decided through the centuries, all those cases wrong.
Well, I don't think there certainly aren't any cases that my friends cite that meet that test. It's not just economic harm; it can be psychic harm. There are other. It can be discrimination.
What's the answer then to Justice Kagan's question? You
Okay,
say there could be psychic harm, there could be economic harm, there could be all kinds of harm, and that being so, why isn't what she said right? That one kind of harm could be the harm suffered when somebody tells a lie about you or gives false information. What's different?
It could be, if I can just finish my answer to Justice Sotomayor, because I just want to make clear, and I think the college savings case is a perfect analogy here, that every cause of action does not confer a property right. The Court there made that clear, and that's why the property right rationale doesn't apply here. Now, turning back to Justice Kagan's question, I think there are other areas other than defamation where there's some guidance about what constitutes tangible harm. For example, in the false light cases, the restatement has a comment that I think this is a restatement second of torts 652E comment C that's very on point. It says, complete and perfect accuracy in published reports concerning any individual seldom attainable by any reasonable effort, and minor errors such as a wrong address or a mistake in the date of employment or similar unimportant details would not
these are not unimportant details. This is they basically got everything wrong about him. You know, they got his marital status wrong, they got his income wrong, they got his education wrong. They basically portrayed a different person than.
Well, Your Honor, your hypothetical, though, is any false statement, and I'm trying to respond to why a rule by Congress of any false statement wouldn't qualify. So there are some legal precedents that tell us.
Here's the thing, Mr. Pincus. It seems to me that the one thing that we have to say Congress is better at than we are is identifying concrete harms. I mean, it's perfectly fine, and I agree with very large portions of your brief when you say they have to have identified a concrete harm, and say, fine, yes, they do. But now the question is, did they identify one? And it seems pretty clear what they wanted to do here, that this statute is entirely about preventing the dissemination of inaccurate information in credit reports, which they seem to think is both something that harms the individual personally and also harms larger systemic issues. And then they gave the cause of action to the people it harmed personally. And I guess, I mean, don't we owe them a little bit of respect that they've actually identified a real-world harm that's out there?
Well, I think there's a threshold assumption in your question that Congress actually identified that as a real-world harm. And I think there are two problems with that. First of all, the structure of the statute indicates that that's not so. The willfulness cause of action that provides for statutory damages applies to every violation of the statute that's willful, including those that don't involve false statements. So by enacting, if the argument is by enacting the willfulness cause of action, Congress said inaccuracy is so clearly harmful that it should be actionable in any case, it's just not possible to look at the way the statute was constructed and say that that was so.
How much more do you think the plaintiff in this case would have to allege or prove in order to show injury in fact?